It's you.
It was me. She was changing chairs, Mr. Speaker.
Andrew Little.
Thank you, Mr. Speaker. In conjunction with my colleague Carol Beaumont, who was shifting seats at the time, I want to record that once again we support this legislation because it does make some important clarifications in a number of tax areas, and that is good. The principles of tax law and tax administration is that the tax payable and the tax system should be as simple as possible, should be as accessible as possible in terms of understanding it, and should be easy to administer, both for workers who are taxed and for their employers or the tax collectors who are administering their tax affairs in terms of collection before imparting the tax collector to the IRD. So the objectives of the legislation are perfectly sensible and normal. I want to focus my comments, Mr. Speaker, on the employment-related aspects of the bill, which cover the taxation or non-taxation of accommodation payments, of meal allowances and of clothing allowances. We have had a good tradition in this country for many years that costs incurred by workers or by employers on behalf of workers so that workers can execute their duties as an employee, can carry out their work, that those expenses are normally win some sort of tax deductibility because they are costs incurred in going about earning an income by that worker, but nevertheless are costs that need to be incurred in order to do so. And they are costs that should not be incurred by the worker, and indeed from the employer's point of view they have a number of business expenses, but that the expenses incurred, for example, providing accommodation or providing a meal or providing clothing, they are costs that would otherwise be a burden to the business and may in fact be an impediment to the generation of that extra employment. So there are good policy reasons why there have been tax deductions. I have to say it is somewhat surprising that in this day and age we find, or this House finds itself in the position of passing legislation that is so prescriptive and so specific on these particular allowances, when I think it has been commonly understood for a long time that expenses incurred in the carrying out of a worker's duties typically are tax deductible. But when we look at the provisions in this bill in relation to accommodation expenses, it makes perfect sense that if a worker has to travel away from their normal point of domicile to another place to carry out their duty, and we will expect that in relation to the Christchurch rebuild, just as we have seen in so many other industries over so many years. The extractive industries, particularly oil and gas, is a classic one, where people typically do travel long distances to do their work. They'll do a 2 or 3 week hitch and they'll finish their duties, their tasks, and they'll then go away for 2 or 3 weeks before they resume their work. The tax deductibility means or encourages or promotes mobility of the workforce and flexibility of deployment, particularly for those tasks and those occupations that are specialist in nature and that are not easily replicable on a workforce that is not easy to train up and create skilled labour in a jiffy. So these sorts of allowances perform a very important task when it comes to the workforce and mobility and flexibility. When it comes to the meal allowance provisions in the bill provides that certain work-related meals will not attract, or at least will be tax deductible, will not be taxable, will not be subject to fringe benefit tax, and that is right and proper. That is the appropriate thing to do, that either paying a meal allowance or paying a reimbursement for a meal is not to be treated as income in the hands of the worker, and therefore is payable tax-free. The legislation does not make it clear, but it is possible, of course, that a meal by a National MP at a Cabinet Club could, of course, come under this provision. It may well be that a meal eaten, enjoyed, supped up by a National MP at the Northern Club or the Wellesley Club or the Wellington Club that falls within their duties, and let's face it, if the recent media accounts are anything to go by, supping at the table of the Northern Club and the Wellesley Club and the Wellington Club seems to be a regular undertaking by National MPs. It may also be tax deductible, or at least a reimbursement of that meal, either by parliamentary services or more likely the head honchos in the head office of the National Party. Members will find that payment will be able to be made tax-free. So I'm sure there will be National MPs who will be breathing a sigh of relief, perhaps, that this now very prescriptive provision will ease the burden that they are under for having to go and have all these meals and no doubt talk about great matters of policy, immigration or otherwise. But I think the interesting thing about all this, however, is that notwithstanding this provision for the tax deductibility of, or at least the tax-free nature of meal allowances and reimbursing payments for meals, is that it runs counter to the other policy drive that this government is making in its industrial legislation. And the Honourable Member David Bennett knows all about this because he's ramming it through at the moment, and that is the removal of meal breaks, the scheduled meal breaks that has been a standard provision in employment agreements from time immemorial. And so it is, there is an inconsistency, Mr Speaker, that on the one hand we have legislation that is about eliminating meal breaks altogether, but on the other we have this for those lucky enough to get a meal away from home, and that they can get it reimbursed tax-free. And then the third aspect of the bill that I want to comment on is the payments for distinctive work clothing. And Clause 23 covers off this particular area. It's a new section in the income tax legislation, CW17CC. The sections in the income tax legislation are now taking on the appearance of a registration number plate for a vehicle. But anyway, in CW17CC, there is a new provision providing for the tax-free provision of either allowances or clothing that is distinctive in nature. Presumably a high-vis vest would be a distinctive item of clothing for those working in hazardous industries. It is just as well that it is the provision of a high-vis vest will be tax-free or will not incur any tax burden, because, of course, the health and safety legislation that this government is passing requires employers, the mandatory provision that employers provide such clothing. And so, of course, there at least is some consistency. Compare that to the meal allowance provision, where this government is busily abolishing meal breaks. At least in relation to the clothing provisions of this bill, there is some consistency. And then, of course, the other thing this bill does, at least in the form that has come back to the House from the Select Committee, is that the insidious attempt to remove the allowance that plainclothes police officers have traditionally had the benefit of, that at least is now removed from the bill, and police officers, at least those carrying out plainclothes work, can breathe easy at night that they will continue to be supported in their very difficult, very stressful role, and that they won't incur an extra burden just because they happen to get reimbursed or receive an extra allowance to provide for clothes outside the uniform that they would otherwise be provided for. So, Mr Speaker, I make those interesting observations. It is good to have legislation that tidies these things up. Tax legislation should be simple. It should make our tax law accessible and sensible and consistent. Ideally, it would be consistent with other government policy. In this case, there is at least one allowance that is not, but notwithstanding that, Mr Speaker, we will support the bill.
Jamie Lee Ross.
Mr Speaker, I only wish to speak very briefly in support of this bill, and I want to touch